Hi, my name is Brad McDonald. I'm a partner here at Godfreys Law, and I've been practicing for almost 2 decades, and my specialty area is employment law, and over my time here I've helped many Canterbury businesses and employers navigate the employment law field. So there are some changes that are coming up in mid-May, a number of changes under the Employment Relations Amendment Act. One of those changes is around the use of 90-day trial periods, which have been in operation for a number of years now, so there's a lot of familiarity out there around them, but they're not particularly used well, and unfortunately there's some issues there. But the particular change that you need to be aware of is for employers with staff greater than 20, you're now no longer going to be able to use these trial periods. However, there are some other things you can do, such as using a probationary period, which is a bit of a different beast, and that would need specialist technical legal advice before you embark on that to make sure that's effective. But if you employ less than 20 employees, come mid-May when the law changes take effect, you will still be able to use 90-day trial periods in your business. So the penalties, if you don't have a 90-day trial period in force and you seek to terminate a staff member under a 90-day trial period, or the 90-day trial period is defective, which I often find they are for a number of technical legal reasons, and they're often challenged and successfully so. The penalties you can expect to be awarded against you if the matter went to the authority, for example, was firstly a finding of unjustified dismissal, and then secondly penalties north of $20,000 plus any legal fees you incur, as well as the legal fees of the other party if they're successful. So all of a sudden you can be talking $30,000 plus very quickly if that were to go all the way through to the Employment Relations Authority. So what you need to do is you need to make sure to make sure that your business is protected, you need to make sure all of your new employees are put on individual written employment agreements. You need to ensure that those employment agreements have complying 90-day trial periods within them, and you need to give them a letter of offer that signals the agreement has a 90-day trial period in it, and you need to advise them of their rights to seek advice before they sign that agreement, and that agreement with the complying 90-day trial period must be signed and returned and delivered into your hands before they set foot in the workplace and begin working for you. If you fail to do that, any of those things, the trial period is potentially open to challenge and therefore being described or held to be null and void and opening you to penalties. So if you'd like to know more on the topic of 90-day trial periods and how to protect yourself and your business by the effective use of these trial periods, feel free to give me a call, Brad McDonald at Godfreys Law, and if I'm not available, I have other people within my employment team here who would be happy to help you and provide you with assistance and specialist know-how.